Welcome to today's episode of Power Over Pain. In this fourth episode of this multi-part series exploring Tom Althouse's life and story and real-life thriller where he's fighting against Warner Brothers and Disney for the rights of the movie The Matrix, where they stole his intellectual property. Today we will show you overwhelming evidence of how this court case was thrown, the fraudulent conduct of the attorneys, the judge, Tom's attorney, and fraud upon the court. What is fraud upon the court and what are the consequences? This is from legalclarity.org. Fraud upon the court involves a deliberate scheme to undermine the judicial process. Fraud upon the court is more than a simple falsehood in a legal case. It is a corruption of the legal system. This fraud is characterized by a deliberate scheme aimed at improperly influencing the court's decision-making process. The conduct subverts the court's ability to adjudicate a matter impartially and is considered an attack on the judicial institution itself, not just a deception of the opposing party. A distinction exists between this fraud and lesser offences, for instance, failing to disclose a document during discovery is a procedural violation, but does not typically rise to this level. However, fabricating a key piece of evidence, such as a contract or a will, and submitting it to the court is a direct assault on the truth-finding process because it manipulates the foundation of the court's judgment. That's what happened with Tom's attorney Rankin, who submitted a false contract.
What is it? The legal contract. And the final segment, you're going to see that highlighted where it's totally legal. That's what the AI was going off on. All the traps in there. And boy, they were dirty dealings. And then you're going to see the lineouts on the stipulation order. Yeah.
What's that blue post-it on the bottom of the Rankin Associates page?
Okay, the blue thing is the state bar, the official state bar entry that says that his license was suspended since 1990. Since 1990. So in 2009, when he's approaching me, his license has been suspended for what? 19 years? And he said he forgot. They were waiting, keeping him like a cell. So he can do stuff on Hawaii, but they're waiting to launch him in California to do the case. That's why he was forcing the case to be in California like they wanted, rather than Hawaii. I wanted Hawaii. So he goes to where he's suspended.
He could practice in California.
He could practice. No, he could only practice in Hawaii. He was suspended in California for those 19 years when he first approached him. So when he filed it in 2012, it was you add on 3 more years. This was running off the statute of limitations. That's 22 years suspended. It's unreal. And he says he forgot.
Why would they rather have him practice where he's suspended?
Because then they could say anything he did for me is null and void, and they win.
Uh-huh.
What they're going to do is they're going to make sure that if there's a malpractice case, they represent him. In the malpractice case, they become his expert witness against me. They were making sure that if a malpractice case, they can handle it with the state bar and California and make sure nothing's done. And that's exactly what happens. In the malpractice case, they supplied their own attorney, and they had their guy or their woman, Linda Burrows, who was lead attorney for Warner Brothers, his classmate from University of Berkeley, being his attorney, so his expert witness, along with others. And so what happens is they get the judge at the bar to say get a letter that says, we're not going to focus on anything Rankin did wrong. This letter is only for you and him. And we're not going to look at anything he did wrong. We'll just remind him not to do it again.
Wow.
That's a lot. That's the letter I got. So
The
they
letter
knew
you
that they
got
knew
from the court.
from the state bar.
Wow.
Yeah. For suspended license and everything else. That needs to be brought
So
up too.
that
I'll show that
shows
letter.
that even the state bar is corrupt.
Completely. Completely.
That's the thing. So
So
like, I was just researching what do you call it? What is the legal term for a corrupt court? And it says
kangaroo court is
it
but I know
what it says one would need to file fraud upon the court. So,
fraud upon the court.
but
Yeah.
and then it shows you the repercussions through the bar. But what happens when the proper bar administration is corrupt? I haven't
That's right. That's
researched
right.
that.
They called them. Their attorneys called the bar judge that was in charge and told him what to say. They talked to the judge in our case and told him what to say. And we've got on tape the judge going, what do you want done? What do you want done? Wouldn't let me talk, only them. What do you want done? Okay, we'll do that. It was unbelievable. Yeah, that's what's on tape. So
My
it's
God.
just unreal. Oh my God. I did a whole motion to compel because they weren't giving you any evidence, weren't going to give it, said they won't. And so I did a motion to compel, wrote it all out. It took about 2 weeks to get it all done. Got it in, and the judge goes to them, "What do you want to do? What do you want to do?" Ignored me. He goes, "Okay, we're just going to leave everything as it is. No penalties. We're going to leave everything as it is." Didn't do anything with my motion to compel when they flagrantly
And
said they were not going to honor anything.
you
Yeah.
mean you filed that as someone that's representing yourself?
I had to at that point. They had all their attorneys playing me. So when I showed up in a malpractice case, right, because I didn't put Rio as the handoff guy, that was also a classmate from University of Berkeley that was sent to handle me. That's a whole story in itself. We'll get that later. But what happened was he's supposed to represent me. And so he didn't tell me that he gave them back-to-back continuations to attack their own client, to do a motion to compel on their own client, telling me, "Oh, you provided everything they need. You're good." But in emails I got later from him to them at the same time, they're saying, "Okay, we'll give you back-to-back so you can extend your motion to compel against my client, and I'll go on vacation." So what he did was a clerk told me what was going on. I show up in the court for a motion to compel against me, and there's their attorney I meet for the first time, this Sohol guy from India. Nasty piece of work. And I was like, "Where's my attorney?" He tells the judge, "Mr. Rios is on vacation. He won't be here and unreachable." Why would my attorney go on vacation with a motion to compel? Why did he give him back-to-back extensions to do it against me when they ran out of time? And why is he unreachable? And I find out about it through a clerk that was scared and alerted me that this was wrong. And then the judge there said, "Okay, we're going to levy it." I said, "I want to fire my attorney. I want to have this suspended here so I can have time to have representation." "Nope, you're going to be charged with not responding and whatever you want." It was Judge Tro who was the one that oversaw Larry Wachowski's divorce case. So it's a
Wow.
cover-up attorney. Yeah, cover-up judge. And he said that I would have to continue and be fined like $5,000.
What is
And he said
the
that, and well, there's one more thing. He said, because he said, "Well, we're going to have depositions, and if he doesn't show up," and the Judge Tro, who's the insider, says, "If he doesn't show up to your depositions, he loses default. He loses." So what happened? Rios says he's still unreachable through his paralegal. And I'm in there in the office where Sohol, the attorney for Rankin malpractice, is calling saying I'm an asshole. He's such an asshole. And she's trying to alert him that I'm in the office hearing this. And so she switches to Spanish to talk to him, to alert him. And then Rios calls on the phone, who's unreachable on vacation. The day that I was stuck with the fines in the court with him no-show. And so I go, and she goes, he's here in the office. I said, "I would like to talk to you," because she said, "You should explain what happened." He told me Rios needs to explain what happened. Then she switches up. So when he's on the phone, I'm like, "Yes, I'd like to talk to him." He says, "I can't be reached." And he gets off the phone. He will not be reached until a week and a half later, where they set up depositions for me without telling me. So I said to Rios through Miriam, I said on a call, I said, listen, I need to know when these depositions are going to be. Where and when? He said, I'm not going to tell you where and when they are. And when you don't show up, you lost your case. That's my attorney. And so what happens is you have to talk to them. So I call Sohol's office. We're not going to tell you. You have to talk to your attorney, Mr. Rios. Mr. Rios just told me he's not going to tell me. Can you ask for more collusion? And so what happens was the paralegal said they have been on the phone with each other to like 4 a.m. on Saturdays and stuff like this all the time, not responding to me. So Rios stripped my file of evidence and handed me back basically an empty box at the end and chews me out saying, he's sick of me, tired of me, that I was the problem. They claim to have a flood in their office that destroyed evidence. They're on the 5th floor, Jose. 5th floor in Pasadena. How'd you have a flood on the 5th floor that was 5 feet of water, quote, 5 feet of water in their offices?
Well, they can allege that their filing system is on the bottom floor, can't they?
No, they said it was on the 5th floor. They showed me all the boxes. So they claimed they were under 5 feet of water on the 5th floor. They didn't say it. At the same time in the corrupt court, Western Division, get this, I'm not making this up. They shut down the copyright office of Frank Ayala. Frank Ayala, who's on LinkedIn, sponsored by or supported, whatever it calls, endorsed by the same defense attorneys that Caldwell, Leslie, and Proctor that represent Warner Brothers. So that's the guy that tells me I have to go to Rios as a handoff from Rankin. And the Frank Ayala is the one also that was telling me that they had bragged about, oh my gosh, so much to it. So much to that's bragged about. It's like fraud on top of fraud on top of fraud on top of fraud. He bragged about how they were saying that I was worth so much, $500 million, that my attorney had my back against the wall, that they were in his pocket, and that I had no idea much of being screwed. That's Frank Ayala telling me that, so I will go. So I'm solicited to go to, yes, you have to go to Rios and Associates. Rios and Associates. Rios and Associates. So Rios and Associates is the one that had the nephew, Ralph Rios, Pasadena from Texas, had the nephew from Texas, who, Rios, that marries my daughter. At the same time the case is being thrown right now. At that time. See how this is? And then Miriam Espinoza, the paralegal, who was in tears when I went to her office before Sohol called me an asshole on the phone with my family there and on the speakerphone. He didn't, calls right away to let them know, report that I got in the way of what their plans were working together. She finds out that she's related to Lenny Coco. Lenny Coco, who was one that had me do the pitch session for Bonaventura, who says he discovered in Shepherd of the Matrix Story in Long Island. Well, when I was at Lenny Coco's house, I had no idea that Miriam Espinoza in my future would be the paralegal for the handoff firm. She's related to Lenny Coco. It's unreal. So it's like they had it all strung up like Art of War. So think of that. Giving them back-to-back extensions for a motion to compel against their own client while telling the client everything's in order. And then not showing up at that. And their defense attorney is the one saying, oh, yeah, he's on vacation. He can't be reached. Why would the judge proceed anyway? I'm there not knowing how procedures work, going, I'd like to fire the attorney if he's doing this and have time for representation because this doesn't make any sense. No, Judge Tro is going to say, no, you're fined. You're fined. And then here's the other part. Ready for this? Judge Tro then resigns himself from the case. He knows he's in trouble. So next thing they do is remember I said that they said if you don't show up your deposition, your case is over? So because since they said, okay, you're not going to tell me, you guys aren't going to tell me, I sent an email, you're not going to tell me when and where this is, I'm trying, so I'm letting the court know now that I have tried to be ready for this deposition. Both of you are not going to tell me where it is. Therefore, what happened? Here's what happened. They threw a fit because the day that the case is to be thrown, the day that deposition is supposed to be scheduled for, is the deadline for filing motion for summary judgment. So they had it all set up in a way, tongue-in-cheek, where I would lose on the day that summary judgment would be entered, the deadline. And so what happens is they miss the deadline for summary judgment because I sent a message to the court saying I'm trying to be there. They're not telling me where it is. I want to be at my deposition. Blew it. So immediately Judge Tro resigns. They have an ex parte where it's an emergency meeting. And here's the rule. They're filing an ex parte emergency session to either extend the trial date or reduce the trial date. What's the emergency? You're going to extend it or reduce it? Why? The judge, it was an interim judge because Tro removed himself. So an interim judge is there, a replacement judge, because they don't have anybody to replace him yet. It's that fast. And the judge is saying to me, what they're doing is they're trying to extend it so they can do their motion for summary judgment on you, extend the deadline, which shouldn't happen. It shouldn't get extended on deadline. Or if that doesn't work, they're going to try to shorten the process so you have less time to prepare and get an attorney. Incredible.
And do you know how these judges get selected?
It's not. They show it in Game of Thrones. It's not by straws. They're picked. Can you do me a favor? This case, can you handle it? It's not random. It's not random, as they
But it's
say.
supposed
They're
to be,
assigned.
in light of
It's
the
not.
law, right?
It's supposed to be, but it's not. You know what? We should have recorded all this. Darn it! Because all that was just explained.
I'm recording.
Oh,
I'm recording.
Oh God! I'm so glad you recorded that because that's so important. Oh my God! God bless you, Jose. This is so important because that spells it out, and what we're going to see is these documents too. So it's like, oh my God, what they've done is fraud on fraud on fraud on fraud, and then bragged about it.
Because
so that's how the Matrix case was taken. That's how the Matrix case was taken.
Even that statement you made, where that same Judge Tro was also involved in Wachowski's divorce case.
He was the one that was presiding over the divorce case between Larry, so he was appointed to handle me. He was the one that was going to work for Larry.
That's another coincidence that falls out of the realm of probability.
Out of all the judges, yeah. And why would he suddenly leave without explanation? Just because the deposition ploy failed that he stated in that court at that false motion to compel. He had stated, well, if he doesn't show up to depositions, then he lost his case. He defaulted. So he's showing he's part of it. He knows that it's going to be thrown that way. That was the big plan between the judge, the clerk, the attorneys on both sides. That's why they're calling each other like 4 a.m. in the morning. They went into a tizzy because I said what I said. I said, I'm going to go ahead and let the judge know, send this email in where I have tried to find out where depositions are going to be held and what time by both of you. You're both refusing. I'm letting the court know I'm attempted, and you refused. Then that's why they're calling each other at 4 a.m. on Saturdays. Not me. They're not calling me. They're calling each other.
But how did you come to find out that they're calling each other at 4 a.m.?
Miriam Espinosa, the paralegal, told me.
And how did she know?
Because she works for Rios and Associates. She's his main guy. She was basically a handler. So she was his assistant.
And she was privy to these phone calls just because she's an assistant?
All of them. She was, she's a paralegal. She was the paralegal for Rios and Associates, who was handling me too.
So
she was the one.
Did they have to document this? It's probably not smart to document it, is it? These phone calls at 4 a.m. on a Saturday.
It was a mistake on her part. What she was doing was she was trying to play at the she's the innocent party. I don't know what's going on. They're doing this, they're doing that. She also had told me that my box of evidence that I wanted, that Rios grabbed it from the office. She told me. She grabbed it from the office. She says, I don't know why he grabbed it from the office. He took your box of evidence with him when he's going to court, but he's not doing your case right now. He's doing 2 other cases. I don't know why he grabbed the box of evidence. He took it to Warner Brothers so they could go through it. Because I showed up in town and wanted to get my letter, see my letter that was very key evidence that they were altering. And so he took the box of evidence with him away and let Warner Brothers go through it. So I got a glimpse of it at one point through Miriam, but they wouldn't let me have it. And in it was all these documents from Joel Silver, correspondence on me, but they wouldn't let me have it. They said the police would come if I even tried to take my own files. So what happens is after that, that box was cleaned out. Rios handed me back at the end after they failed in getting that first Jay Ploy, or that first thing where I'm not showing up my deposition because they weren't going to tell me where to win. He hands me back this stripped box down to basically nothing. He's actually rocking in front of me, like mocking me. The one lady who was their receptionist was named Colin. Her last name's Colin, believe it or not. And she was a dispatcher for the police force, 911 dispatcher. So they had her as the receptionist as long as I was there. And then she switched back to dispatcher. And she was actually on the phone with me when we had the break-in at my house. And it was her, Colin. And she was saying, we're not going to do anything about it. You did it yourself. You're the one that broke into your own house. We're not sending anybody out. She was the receptionist at Rio's Association.
My God.
So it shows the police working with the judges, working with the attorneys on both sides, working with the clerks. Can you believe this? That's why the Matrix case should never. That's why it's a story. They're calling it the greatest story. But go ahead.
Yeah, no, I was just about to say this is like a Hollywood thriller at the highest level of real life. Like it couldn't be. You couldn't put this on the screen.
No.
A more entangled thriller on the screen than what you have in real life.
That's what the attorneys in Hollywood, top firms. I've been to different top firms trying to see if somebody would help us. They all said, your real life story is bigger than the Matrix itself. So you just hit it on the head. You hit it on the head. That's what they're saying. That's why Warner Brothers did the Richard Jewell story. The Richard Jewell story was a test story by Warner Brothers to see if this story would be popular. That's why Disney was making the offers about come work with them if they could cleanse their part out.
What is the Richard Jewell story? I've never heard of it.
Richard Jewell story is about a guy who is a whistleblower, basically. He's speaking out against the FBI, and all these things that happened to me happened to him. So he's like a regular Joe who goes, if you look it up sometime, look up Richard Jewell story, and you'll see how Warner Brothers crafted this whole thing as a test story to test the validity and power of our real life story. So they're getting greedy. Not only did they want the Matrix story from us, the Immortals, they also want our real life story to control that. Now, what they would do in Warner Brothers' case is replace me with somebody else and make it a third party fictitious, or use the whole thing, and that's a big slap in my face. Yeah. See? Yeah. So anyway,
and also in the first episode, this is something I've been thinking about over the last few weeks. In the first episode, you started out by saying that there's a connection to Bern, Switzerland.
Yes. Oh, yes. And
that made me think about the particle accelerator that's in CERN. Do you think that do you know anything about it? And do you know anything about the Mandela effect that people suspect is being fueled by it?
Well, people need to understand that the Nazis never lost power. The Nazis were simply buddy with the U.S. and absorbed by the U.S. A lot of us know that Operation Paperclip. We know about maybe not Operation Sunrise, but Operation Sunrise was being conducted by Alan Dulles of the CIA during World War II, like in 1944, 1945, out of Bern, Switzerland. So my family home, Bern, Switzerland, ancestral home, is where Alan Dulles was working to see if he can get the top level Nazis to be part of the U.S. infrastructure. And we're talking SS agents and even Goering. He wanted Goering. During the Nuremberg trials, he was arguing to let Goering go to release to his custody in Bern, Switzerland, so we can take him to the U.S. and employ him. All the secrets and everything. So this is fact. And now the CIA is letting it be known that, yes, they were involved in this, that they were involved in it. The Immortals talks about this. The Immortals talks about, in the opening sequences, it has Forever Young sequences, which they used in 93 when I first submitted it, and with Mel Gibson. So what you've got is this idea that it wasn't Argentina they went to, it was Brazil. And now we have facts that the submarines, those about 68 submarines, They stopped at Rio de Janeiro first. They stopped at Brazil first before they went down to Argentina. Argentina was a cover,
Right.
smoke and mirror. It was Brazil where they were operating mainly. There was a subsidiary group in Argentina, but the Hitler group was in Brazil. That's where they had the most control. That's where they sent people all the time. So the infrastructure was already planned out and set. In Bavaria, they had the Eagle's Nest and everything else, and all those tunnels, and the SS was all there. The SS was called to the Eagle's Nest area, Bavaria, when the Russians were coming towards Berlin. And Hitler was not in the bunker. Hitler was going to where it was all set up ahead of time, the safe zone at Bavaria, with his SS called back to help protect him so they could then use that underground tunnel, which went through Rome and also up to the substations in Copenhagen. So what they did was they had two different routes, and it was the Red Cross and the Vatican that took care of the top level Nazis. And there's a church that they have, a documentary shows this too, where they actually rebaptized them with new identities. It's like a cult ceremony in this Catholic church where they rebaptize them, and the book shows all the entries of their old names and new names as they're baptized into a new identity to now work for the US.
And,
So German citizens know this, that they're under the US. And that's why Pat Robertson had all these ex-Nazis in his organization that dealt with me. Schonoff, Schlosser, Elser, Hunt, all these guys were Nazis. Yeah. So when you talk about that CERN thing, it's Nazi controlled. Really, I mean, European groups are involved, but America has never let go of its grip on the world. It uses agencies to keep that control, and its military. And also it has Nazis employed. And the excuse was this: they will be the best buffer against communism. Everybody talks about communism, but they're forgetting about fascism. We employed the fascists to be the best fighters against communism. The greatest enemies were Hitler's fascists and Stalin's communists. So we took on, what's that phrase? The enemy of my enemy is my friend, something like that. So we took the greatest enemy of the communist group and employed them and absorbed them and took them on. And Dulles almost got Goering. So that's why the rocket ticket and everything else. It makes sense?
and how did you include this into the Immortals? These don't match up to the Matrix, do they? This is something that's in the Immortals that is
what
in
what
the
they
original
did.
screenplay, but didn't get matchups to the knockoff version.
No, they split it up. They chop shop the car basically. So they took the different things and moved them around, like they put stuff in Man in High Castle. So what you've got is like Philip K. Dick after he died, they used that to launder my stuff into blending with Philip K. Dick's work. And so what you've got is they chop shop it and use it different places because they didn't understand the work. And so what they do carry over, and that's what that discussion with the head of the story department at the time, Diane Bellis, and I had happen, is that you find her saying no one's going to be interested with anything Hitler in it, you know. And so what she did was they changed Hitler, who wanted to be an architect, and boy, did Rankin battle me on this one. He didn't want this known. That Hitler's plans for after the war was to be an architect. He wanted to be an architect. He did drawings because he didn't get accepted into architecture school. And so this piece right here, what you have in the Immortals, is you have this piece, it's blurry here. This piece has the architect named for the historic figure he's based on, and Warner Brothers just calls him the architect because they don't want that heading. They're going to put it later in Man in High Castle, that character identified that way. So that's why Rankin was arguing there's no, Hitler was never an architect. He went on and this. I'm like, so I showed over and over again, Hitler, yes, all these films, they show him drawing the pictures, all the pictures he drew, all the architecture. That's why he was real close with his main architect, who they wanted to design that big dome, like 10 times bigger than St. Peter's. That's why I put the dome in there. And that's why they kept the dome. So you're going to see all these bleed overs from the original work. But that's the backstory, is that what group in history would want to create an immortal program that would make a one world society where they controlled it for 1,000 years? Well, there's only one reel that fits the bill, unless you want the US and their aspirations that are now attached to that. So we ended up trying to perfect what the Nazis almost achieved. We went to perfect it. And that's what we're doing in our time. So that's why I've been trying to urge the agencies, and I think we're succeeding, to do the right thing. And that is, I think that's why my screenplay original drafts are being returned to my home 2 days before Easter. All these things are showing up. That's according to Michael Jaco, like I said, the CIA film department. So they're helping us now. They are being the good guys, just like in the original script. Who are the agents? Why is there an Agent Smith? Why is it agents in the program? Because we have agents in the beginning too. Neo is a lower echelon department head of the FBI or CIA, and I'll have to look again because it's one of those agencies. And then you've got Smith is an upper echelon department head. So you've got the agents in the original screenplay becoming the agents in the stolen work. So there's carryovers all over the place. That's why they have the hooked up with the earpieces and such and the Jackson neck. So it's all there, but like you said, they strip it and dumb it down and dull it down. So they don't have an historic figure in their version for who the architect is, which they should. If they did their homework, they should have somebody that we can say, oh yeah, in real life, that would be like this person. No.
Yeah.
Yeah.
They
stripped sense. It and left it done. Yeah.
And what's why did you also choose it to be Zion, the city of the resistance?
That's how I pitched it. I said there's Zion, but what I did was I changed it. I then looked up, Zion, because that was the scripture I got before I wrote it. Before I wrote it, I was asking God, if you will. I was in tears going, Lord, if you're there, if you're real, show yourself. Let us see you. Help us, and let us be with you like children with parents. Let us be with you. Show us a way that we can prove ourselves to you. And I got a scripture by my bed, like I was led to that night. And it said something like, my son found it, like blindly just found it. It was, the sons of Israel will ask weeping the way to Zion, and I will show them the way and make a covenant with them forever. That's why I wrote Zion in the original work. Yes, Zion. That's why they use it, right? But then I thought, well, for public audiences, let me research what would be the best underground city. See, I'm trying to, again, tie it to what's historic. And it came up with Wintergreen. Wintergreen, I found at the time, was the government's underground city. And so I pitched that and called it Wintergreen, the underground city where the last remnant of humanity would be. And it had the cavern and everything. So it's there. There you go. So renaming it back to what I had doesn't change the fact that they're using exactly what I had, the underground city, where the last remnants of humanity are there, right? And that's where the blue pill is given back to Neo when Neo is cut from the program. So it's not given at the same time like Alice in Wonderland. Anyway, so it's a great question you asked, because all these things, when you put them back, it'll make sense and tie in historically. And it'll tie into my life, like how that interrogation scene came from my real life. Wachowski's never had an interrogation scene in their real life. I did. So that's where the passion comes in. You'll see the passion in the original work that's lacking when they stripped it, because they didn't care about it. And that's why they stuck all my personal information in. They said, that the graphic designer said, to keep the project interesting, because they weren't interested in the project. They mocked it on set. It wasn't their baby. Anyway, that's what it is.
When did you have an interrogation scene in your life before writing The Matrix?
Pat Roberts' organization. After I was approached by a sex ring, like Harry Sova is now at Liberty University, is one dean of his communications, took me in a motorhome to Washington, D.C. I was roofied, I was raped, that kind of stuff. So what happened was I was called into a meeting called the President's Meeting. And Robertson had this orchestrated.
Yeah. So you explained that to us during the first episode.
So that's why the interrogation scene comes. That's why I wrote that. This is the first scene I wrote. That's why it's the first scene I shot. That's why they stuck my stuff in it, my high school and everything in it, to mock me, because that was the most pertinent scene in my life, was the interrogation scene.
Okay, very well. So
it's the heart of the piece.
Do you have those court documents on your computer that you can screen share with us and go through them?
Wait a second. Right here. Let's call this up first. See it?
Yeah.
Okay, great. This is good. That's a good idea you had. So look at the bottom line. I'm going to see if I can make this a little bigger.
Yeah, we can see it. But okay, maybe now, I'm not sure if you can enlarge it. Oh, no, but we can see it properly. Yeah, that's good. Yep. Okay.
Okay, now look at the bottom line. It says administrative actions. See, it's Tony Rankin. Tony Rankin, right? There's his
Anthony
number.
Lawrence Rankin.
State Bar of California. It says there, July 30th, 1990, not eligible to practice law.
Mm-hmm.
Then at the bottom it says 7/30/1990, suspended, failed to pay bar mentor fees, not eligible to practice law. So when he approached me in 2009,
And where does this
from
document
19,
come from? Where does this document come from?
this is the bar. This is from the State Bar Association website.
2016. You got it from the website. Someone else did.
Yeah, yeah. No, I did. I got it right from their website. This is the State of Bar of California website.
Mm-hmm.
It's all fit. That's why it looks so nice. See the seal up at the top?
Yeah, yeah.
So that's what this is. So look at that. So not eligible to practice law, and yeah, republic. Okay. So anyway, so since 1990, that's what in 2009. That's 19 years in 2009 when he approaches me, and in 2012 when he files falsely for us, that's 22 years, I
Can
believe.
someone allege that you didn't do your due diligence by hiring a lawyer that was not able to, that didn't have a
no,
license?
no, because the trick was he was licensed in Hawaii.
Uh-huh.
See, so I'm in Hawaii going to him wanting to do the case in Hawaii. He's like, no, we'll do it in California. I'm licensed in California. So I'm seeing that he's licensed in Hawaii. So I'm thinking he's legit. You don't go farther. He's saying he is, but he didn't tell me he's has a suspended license in California. Plus, he's saying that he's going to California for major cases on a weekend. He said, I'm going on. I got 2 major cases in California. How? How does he have 2 major cases in California when it says right here he's suspended at that time?
Right.
And that's what's so wild is when he comes back with a whole new staff from California. He was going on a weekend. Comes back with a whole new staff provided by Warner Brothers, Sam Schneider, and all these other nasty people. And he has his offices remodeled, a brand new kitchen, boardroom, board table. All this is remodeled. And he said this. He said, yeah, when I was on the weekend, when I went there with those 2 major cases, I ran into Linda Burrow at Disneyland. I ran into Linda Burrow at Disneyland. What? So he has 2 major cases on a weekend. He's gone for a weekend in California.
But still has time to go to Disney World.
Disneyland, right. And he just happens to run into his classmate from University of Berkeley, having cotton candy and a lollipop at Disneyland? And he says this, and get this, Tom. He talks like a crackhead. He says, get this. She's going to be representing them in the case we have. How would she even know there's a case? If you're arguing 2 major cases and you somehow had the time on a weekend to do it, I don't know how you're doing that on a weekend, and you're at Disneyland and you're running into her out of all the crowds, all the places, and you have a conversation too in that short amount of time where you say, hey, I'm going to be representing the case against you. Really? Small world. Why are you even discussing it when it hasn't even been filed yet? How'd it come up? The deal is that they came there together to meet with Mike Lang of Disney, Harvey Weinstein's boss, who provided my wife at the time. And they were coming up with the strategy of how to throw the case. And he comes back with a whole new staff and Warner Bros. Attorneys and staff members and a whole remodeled office. And his partner, Drewer, is no longer his partner. All in a weekend.
Wow.
Isn't that incredible? How blatant this is. You go back to what you said about it being a movie, like this thriller. Look at this part. Okay, let's get this out right now and go back to another document. So here's the legal contract. This is very, very important. Now, Jen Marie, the amazing, beautiful girl that does my website and everything else for me, she's like my pepper, like, Iron Man's pepper. She ran this through AI. Can you note what happened too? Can you note what happened?
I will. Absolutely.
When we pull this up. Yeah. You can say it now if you want to. It's like what happened. We pull this up.
Oh, but yeah. Please note that back in, I'm not sure if it was 2019. I think it may have been about 2019 that Tom Althouse and I connected. And shortly after I started interviewing him, in my YouTube channel was nuked, or that was banned. That was my previous channel that was banned. Back in 2021, all of my social media channels were taken down. Um, it could correlate with Tom Althouse and the fact that I was sharing all of his information. But back then, as soon as I started, there's this one time, because I'm caretaking my parents, and so they live with me, and I was in the bathroom, and I heard my mum from the kitchen. We live on the sixth floor of a very, very narrow street in Porto. All streets are pretty narrow, except for the main streets, and there's high buildings everywhere, so it's not easy for choppers to negotiate themselves through our skies. My mum, while I was in the bathroom, started screaming, "Jose, Jose, come here! There's a chopper outside our kitchen window." Imagine you on the sixth floor, this black chopper was flying outside of our kitchen window, and I came running and just saw them taking off, and they flew about 3 kilometers north and landed behind some trees. And now today, when Tom was narrating this information that they don't want us to see, they just basically took down my laptop. I'm sure they're listening. I don't know why they do this. Their attempts to silence him are futile. I've already taken the previous episodes and this episode into an external drive, just in case they nuke my hard drive and main board. But we're now back with a new link. Not sure how long it'll take them to try to interfere with this one. But let's get back to what we were talking about.
All right, very good. So we were talking about the attorney contract, the illegal one. And now Jen Marie, the beautiful girl who's been like doing the website and everything for me and doing so much work, she, like you, she ran through AI chat a check on the contract, and the contract is something that the attorney Tony Rankin, who's connected to Warner Brothers, a defense attorney, who solicited me to represent me on a contingency, he claimed, never wanted shown. He never wanted this contract shown. In fact, at my deposition, he argued with the other attorneys when they said, "Let's, can you show us your contract?" He objected for himself, not for me. He objected for himself, saying, "No, you can't see it." And when they argued that's their right to see it, they said, "You can put demands in. I'll fight those, and we'll give them to you anyway." So basically, we'll be able to see that later. But this contract was never supposed to be seen. So Jen Marie put it through a test for traps and fraud, and AI came up with 5 traps, 5 fraud-based traps. And so it was interlaced with all these things. There was many things Tony Rankin did to make sure we never have a copy of it, and which included throwing our case by running out the statute of limitations with a suspended license. So we've shown the suspended license where it says on his original entries that he's not eligible to practice law, suspended since 1990. So what he did was run out the statute of limitations on our case over 2.5 to 3 years, not telling us he had a suspended license. Once the cases missed the deadline, where he went on vacation a month before the agreed time to file, which would meet the deadline, and doesn't show up until the day after that deadline is missed. So a month of being AWOL and not being able to be reached, not returning phone calls, not returning emails, not returning any kind of contact. He then appears the day after saying, "Oh, I guess we lost." So we were like, well, maybe we still have a chance. We might have discovered a little bit later. They knew we hadn't, that our case was definitely thrown. At that point, he was saying, okay, let's see what we can do with Warner Brothers to go forward, because they knew we were already thrown and lost. We had missed the date. They knew that. We weren't sure. They knew. So why not go forward and get all our evidence and alter evidence, destroy evidence, things like that. So then Warner Brothers attorneys act as his sponsor to get his license restored in California because they want it restored so they can use him to handle us. And that's after he refused to serve the defendants. Again, went missing. Again, after he filed a pro per, he went missing. And so we said, well, we'll talk to the judge. That's when Tony Rankin appeared again immediately and said that they were going to sponsor reinstating his license. Should have been a red flag right there. And that they were going to give an extension for serving the defendants. He had missed it. Again, they're throwing the case that way. Let's go to his contract, though. So here's the second page of the contract. So what you have is this number 7 says, in the event there is no recovery because the case is lost at trial, or because client agrees to attorney's recommendations that the case be pursued no further, agrees that the case be pursued no further. He had said to us this quote we kept hearing from him saying, I just want to give Warner Brothers everything they want and be done with this. So this contract is built in that he can throw our case at any time. And if I don't agree with him, there'll be penalties. Isn't that something? So if you look at 9, it says, in the event client fails to adequately cooperate with attorneys or demands dismissal of the case against attorney's advice, then attorney may withdraw from representation in this matter and shall be entitled to applicable attorney's fees based upon their established hourly rate. What Jen was pointing out, and I'll show you the breakdown later here on the 5 traps.
Sorry to interrupt you, Tom. Sorry to interrupt you. But do you, I know a lot of people that may watch this will be skeptics, and they're going to say, you're just showing something that you may have produced yourself because it doesn't have Anthony Rankin's signature. Do you have this contract with his signature on it?
Yes, there's another one we do have that has the signature on it. So, yeah. Okay. But it's interesting you brought up, too, because at first he didn't give us our contract. It's an important point you just raised. He didn't give us the contract in the first throwing of the case, which is running out the statute of limitations over 2.5 to 3 years, where he kept, having us work on the matchups and then send it back saying, we need more, get rid of these, we need more, and we'll work on it. For 2.5 years, he ran us through the ring like that. At one point, we finally got so tired of it, we sent the same stuff in that we sent before that he said, redo. And then he said it's perfect because the time was running out. So he ran out the clock on the first filing without giving us our contract because he never wanted it shown. Then what he does is he goes and files a one later, and it was supposed to be him as our attorney, but he has a suspended license. He didn't tell us that. So he files it pro per and forges my signature. Forges it.
Wow.
And so he files it pro per, and at that point he sends us an email saying, okay, game is on, we're on, but I'll have to tell you something later here. And then explains later in the email trail, you'll see this in the email. He says, I forgot my license was suspended. What, for 22 years? You forgot it was suspended for 22 years? And he goes, so I filed you pro per. Yeah, absolutely, crackhead. So wait till you hear how he talks, too. It's like, I had to do it. This sounds like Larry Wachowski. Anyway, so what happens is he then also says, listen, I don't remember if I gave you a copy of the contract. Yeah, he doesn't remember that either. And like the 22 years of suspension on his license. So I don't remember if I gave you the contract, but I'm going to draw up one that's just like it. And that's where we got this one. See?
Uh-huh.
And so, that's why this is interlaced with all these traps. And in it here, you'll see if the withdrawal from representation in this matter shall be entitled to applicable attorney's fees based upon the established hourly rate and reimbursement of all out-of-pocket costs and expenses in the event client discharges. If I try to fire him while he's snowing us and saying I want to give them everything they want, Warner Brothers everything they want and be done with you, then attorneys shall be entitled to immediate reimbursement of all their costs and fee based on attorneys' regular hourly rates or the applicable percentage from paragraph 3 above applied to the most recent settlement offer from defendant at the time attorney services are terminated, whichever is greater. So here's the deal. If we fire him because he's corrupt, as they bragged he was corrupt, then he gets our settlement too. Even though he's fired, he gets the money from our settlement if we win. Isn't that incredible? And let's look at paragraph 3. So go back to paragraph 3 here. He said, attorney regular hourly rates.
No,
we didn't. What he did was he put markers on it, like a real estate agent puts little arrows. He said it's the same thing. He did this whole snow job. Just trust your attorney. This is just the same thing as a formality. Just sign it. We didn't know any better. We're supposed to trust our attorney, so it's not our fault because we're supposed to trust our attorney. If attorney says representing you is bound by ethics, then you can trust your attorney, you're told, if he's under contract.
But you did
So
sign it. You did sign a
yeah,
contract
it's
like this.
not our fault at all. Not our fault at all. He won't get anywhere with that because we were listening to our attorney. He already had us on contract. See, from the earlier one. So he's saying we're just signing what we signed before. So we're not at fault for this. He is. He is. It's fraud. It's con. And it's traps. So we're good. So what happens is, if you go back to paragraph 3 where he just said you'll get applicable percentage from paragraph 3 applied to most recent settlement offer, which is the highest,
Hang
and
on, but
all
we're
attorney
not
services.
looking at paragraph 3. What
I'm
you're
going back to
showing
it.
us is the last
Yeah.
page.
I'm going back to paragraph 3 in a moment, but I'm setting it up.
Okay.
So what I'm saying is when we go back to paragraph 3, look what he's saying. All the costs and fee based on attorneys' hourly rates, the applicable percentage from paragraph 3 applied to the most recent highest settlement offer, let's say it's $3 million, from defendant at the time attorney services are terminated, whichever is greater. So let's go back to paragraph 3 now, see what he's talking about. So paragraph 3 says, attorneys shall receive as a fee for professional services 40% of any settlement recovery obtained. That's a lot. So what's 40% of $3 million plus all pretrial work on case services, out-of-pocket expenses, all filing fees, all costs. So he'll get more money.
He's expecting to throw the case, so he's not expecting to get 40% of anything.
Here's the deal. Here's the clutch. He's going to throw the case, but if they settle with me after he tries to throw the case and he's fired, get this. If he's fired trying to throw the case and I get a settlement offer, I have to pay the fired attorney 40% of my settlement plus all these other costs out of pocket. So he collects from being fired. See? Yep. So he wants me to fire him. That's why he's saying, I just want to give attorney Warner Bros. Everything they want to be done with you. That's why he's calling me apparently schizophrenic, calling me delusional. That's why he's taking me on in front of them at my own deposition saying, we don't need any rank speculations from you. He's trying to have me fire him because he'll collect everything I'll get, basically, if I win. This is a super con. It's a super con on top of everything else in the story of cons. And who are we dealing with? Let's take a look one more time. What we're dealing with right now, or what we're dealing with, is this guy. Suspended license since 1990. Ineligible to practice law. So we have a criminal doing criminal acts, going to extortion, get money from a client he's handling for Warner Brothers. So he collects from Warner Brothers, paying him off. He collects from the client he burned, who he has an illegal contract with. The reason they're blocking this, crashing your computer, never wants this to be shown, he's screaming, never show this, is because this reveals just how deep the fraud goes and could reactivate our whole case, I'm told. So let's go back to that. Yeah. Now let's go to the correspondence. So right here is something really amazing. I don't know if you can see this at all, but here's an intercepted email where he was going to do a stipulation order. Now get this. He writes, Craig, we have received the proposed protective order and explained it to our client. He's talking about Sam Schneider when he met Burroughs at Disneyland, right? On the weekend when he had 2 big cases of suspended license, and she'll be representing the case for Warner Brothers. He's saying the supplied guy that she supplied for him and for the office to help him cheat me. We have received the proposed protective order and explained it to our client. He had not ever showed me it. He had one concern, which is to make sure that the agreement does not prevent the use of protected information if the case goes to trial. Now, this is very important because what you're going to see in this document following is that protected information, use of it doesn't matter because they're going to make sure you never get it. And that's what this protective order is going to ensure, that you never get the protective information. So he wants it to say, change it to, the protective information can be used in court if you go through all the procedures that you can't possibly do, which will include If you item by item, it has to be item by item. If you want to have, like, say, I want Larry Wachowski's birthday on record, then I will have to have an ex parte, an emergency hearing where it'll be delayed and it'll have to be argued why I want that birthday. And if it's refused or not, and they'll be saying it's protected and all this stuff, and we have a contract, a stipulation order that the client agreed to, that the stuff shall not go through. This up to our discretion. So therefore, this ex parte is a win for us. Now think of that being done by item by item by item. We want to have the screenplay. Okay, you have to declare what page you want, and we'll have to have an ex parte on that page. It's that bad. So what you have is he's lying, saying that I've reviewed this and I'm good with it. If I can answer that question definitively and make sure we are in agreement, he says, on the answer, then I will have no problem with the agreement. So here he is, right? Now, let's go back to what happens with me. So I see this. He's so stupid. He puts an attachment of my name on it, right? So I get it and I respond. I say, hi, Anthony and Tony, or Tony, Anthony and Sam. I appreciate the effort you both have continued to devote towards legitimizing my credibility with claims in this case, which they haven't. I'm just being political. Absolutely. For the record, because it's being seen by the other side too. For the record, I absolutely refuse to give my consent in signing any form of confidentiality agreement at this stage of discovery, because they haven't given us anything. My team and I strongly feel that there is no valid reason for all information related to this case not to be entered into public record. Once I am satisfied that depositions have been served to Joel Silver, Lana, and Andy Wachowski, and Warner Brothers, as well as the other parties we have previously named, I'll be more than amiable to considering questions of partial or full confidentiality on an item-by-item basis. And boy, did this piss them off. Rankin blew it. So Rankin's going to get angry. So Rankin writes this. Tom, I left you a voicemail. Please call me. In the meantime, do not CC opposing counsel anymore under any circumstances. See, he's really pissed off, right? He got caught. I need to be the middleman on all communications between you and the other side. That's how it works when you have a lawyer. Period. No room for discussion on this point. Anthony.
Yeah, you certainly projected him a curveball, didn't you?
That's right. And then now watch this. He reveals his lie. Remember he said we'd gone over this with my client, and he agrees. Watch this. Craig et al. He's so pissed still. Craig, everybody. The email from Tom Althouse below should obviously not have gone to all of you, so you may ignore it. He's trying to say it can't be record. I will discuss the I will discuss the confidentiality agreement with my client after I get an answer from Craig to the email I sent last night. I've not had a chance to talk with Mr. Althouse at all about it yet, so his position below is not yet fully informed. Yeah, he just admitted he never told me about it. He never told me about it. So he lied. He said that he had gone over it and I had agreed. No. As for depositions that Mr. Althouse mentioned in his email, I do not want to schedule at least the 3 individual defendants before the deadline. I mean, I do want to schedule before the deadline, but I also want to get your written discovery well in advance of depositions. Now get this. He said that he would agree to disagree never to have the written discovery, and he never scheduled depositions and never did my discovery for me. So he set us up. Isn't that something? So this is another setup, this whole thing here. We'll talk scheduling at a later date. He never does, really. And if there are times when the Wachowskis plan to be in LA and you'd like to do their depositions there, let me know and we can try to work around that. He's just setting up that they're going to respond. They're never going to do it. And he allows them never to do it. In fact, he's on tape at that deposition of mine where he gave the wrong tape recorder back when they said they have no working drafts. So it's a moot point to ask for discovery. He said, okay, well, I'll write a letter so we can agree to disagree. And that way he covers his butt. And then shoot me out, saying I had no case. Okay, now let's go to the next one. Now watch what happens. So what happens then? Okay, all right, that's that same one. Now let's go back to so what happens is this. There's a meeting held, and I record the whole meeting, right? And in that meeting, he starts out by chewing me out right again. You hear it on the tape. Tom, never talk to them. Don't ever CC. Don't ever do that. I'm your attorney. If you can't work with me, So he's like, chew me out. And he says, the stipulation order cannot go in without your signature. I'm like, I'm not going to sign it. That's insane. Then it gets into this. I said, what about deposition with Joel Silver? And he said this. He said, Joel Silver has nothing to do with this case. Nothing to do with the case. He's not involved in Matrix at all. What? Then he goes, you're part of grandiose delusions, thinking Joel Silver is part of this case. Grandiose delusions? I get up from the table and walk out at that point, and the tape recorder keeps going. When I come back, he's like, we're not going to have any depositions scheduled until we have written discovery. That's how it works. And Sam, the guy supplied by their attorneys from Warner Brothers, is backing him up. He's like, you mean you would say that you'd like to have deposition without written discovery first? I'm like, we need to get depositions of these guys now. We need to know what they know first, what they're going to admit first. Otherwise, if they get everything from us, they'll know what to duck and cover from. But they wouldn't do it. They never gave me anything. They only scheduled mine without having discovery. So watch here what pops up. Rankin tells me this. Let me go back a second. Rankin was told I would not, under any terms, sign a confidentiality agreement where it says for attorney's eyes only, not for judge, jury, or plaintiff. Attorney's eyes only, the evidence will be shown to, because Rankin's on the inside. They bragged about him being in their pocket, right? Later. So why would I sign something where I'm not allowed to see the evidence they have that they claim through the news they have tons of evidence, that Rankin says they have tons of evidence? Why would I sign something where the judge and jury and I never see the evidence? The evidence they don't have because they don't want it on record. They don't have evidence, see? So I'm not going to sign it. So he says, okay, well, we can't proceed unless you sign this document and agree to it. Then he tries this twist. I'm sure after you sign it, they'll work with us on showing us certain documents. Are you serious? Are you serious? Again, I'm not going to back. I'm like, no, I will not sign that until they take it out. That clause.
This guy is insulting your intelligence the whole way through.
All the way through. Thank you. Absolutely, yes. And does Aiden's later, too. So what happens is I say, I won't sign it. You can't send it in. He's like, okay, fine. What does he do? What do you think he does? He submits it without my signature. He submits it when I told him don't ever send this in.
Is that where he forged your signature?
Yes. Well, actually, he put on the document, he forged my signature on the pro per signature when he was supposed to file as my attorney and filed me on. Instead, he said he'd do me a favor by forging my name on it to get a pro per in after we already passed the deadline. So after 2.5 years and 3 years throwing it. So look at this, though. So in the language you see, it says, plaintiff has brought a copyright action. So then it says, to support the claims, defendants intend to produce various documents, intangible things, whatever. And then it says, okay, here it goes. At the beginning, plaintiff, Andy Wachowski, Warner Brothers, Lana Wachowski, Joel Silver, collectively the defendants, and plaintiff Tom Althouse. The parties shall be referred to as collectively as the parties by and through their undersigned counsel. By and through their undersigned counsel of record hereby stipulate and agree to the request for an entry of the following stipulated protective order governing the procedure, use, and disclosure of confidential information in this action. Did I agree? Did I request it? Why is that language there? I absolutely refused. But he sends it in anyway. Now I get a statement later, an email that I have later. He says this, like, remember, we thought he wasn't sending it in. You can't send it in without my signature, right? So we get this message from him about a week and a half later saying, well, the judge, the judge ruled mostly in our favor. Ruled mostly in our favor on what? What? What did you do? Oh yeah, the stipulation order I sent in. He ruled mostly in our favor. Ruled mostly in our favor. Watch this. Similarly, in response to defendant's discovery request, plaintiff will produce certain documents and tangible things in his possession, custody, and or control, including relating to compensation payments or royalties as received or has continued to receive for his work and employment history and income since 1992. What I understand here is he's going to say, I will supply everything without any stipulation. But they are going to do this. To address concerns of propriety, commercially sensitive or private, and avoid lengthy and expensive litigation over the issue, the parties agree that a mutually appropriate protective order will speed the discovery and litigation process. No, I didn't. Therefore, the parties believe good cause exists for designating such information confidential or highly confidential, attorney's eyes only, as defined in paragraph 7 and 8 below. Look what just happened. So, mutually appropriate, that we've agreed that it's mutually appropriate that they can say attorney's eyes only, confidential and highly confidential in all their documents? Is that incredible? And this was sitting against my wishes. Now watch this. Look at the line out on this. So this is the clerk lining it out as this can't be done. They're trying to sneak it through on what? Page 11? Page 11. It says on top. So they stick it on page 11, trying to sneak it through. And look at the clerk's entry. The court cannot agree to the stipulation regarding use of information at trial. The instant protective order is before the court for discovery only. So, and attorneys only. So it's like they're trying to make it so that in trial, nothing will be seen by the judge, jury, or me, even at trial. They're cheating. It's fraud. So look at what's done there. If a party seeks to include or reference any protected information, and they're going to say everything's protected on their end because they don't have anything, any filings with the court, the party must first comply with the procedure and requirements for filing under seal set forth in Civil Local Rule 79.5. Now, this is how you do it, Jose. What you do is you put in legal official language and cite codes when it has nothing to do with what you're talking about, really. And they even have an entry. They put for the Northern District of California. They put Northern instead of Central.
Uh-huh.
That's not by accident. They put the wrong court in. That's to protect themselves. There's some weird thing they were twisting. Then it says, no party shall file any documents with protected information without complying with these procedures and requirements for filing under seal. What the heck? So they're going to make sure nothing goes in by making it look like they're following law, right? Then here's 19's completely scratched out. Now 19 follows 18 because this is the kicker. In the event that this matter proceeds to trial, if any party seeks to introduce information designated confidential or highly confidential for attorney's eyes only, can you believe that, attorney's eyes only? The parties shall meet and confer regarding whether and if so, in what manner such information can be used and presented at trial. So they're saying basically that if there's anything we want to do, like reveal that Joel Silver's with Matrix, right? They can say he's not. That's why they're so blatantly saying he's not. If we want to show that he's in the credits as the producer, as he is in Matrix, dispute that, then they will say we proceed to meet and confer following along these guidelines and say that, well, you agreed to this. You agreed that we decide what goes in and what doesn't. That's what they say.
And those handwritten notes of Central SHS, that was done by the clerk.
The clerk of the judge.
Do you know what SHS means?
That's the clerk's initials.
Aha.
Or whatever it is. Susan something. So now let's go back up. Ready for this? Another paragraph. Okay, they lined this out too. She caught it. She was very thorough. This clerk was very thorough in going through this. So here they tried it on 24. That was 18. They did that bomb. So let's go to like page whatever, 14, 15, and stick another bomb in. Nothing in this stipulation protective order shall be construed to supersede other protective orders entered in this matter. So they'll be able to stack it. To the extent that certain information is subject, other protective orders entered in this matter also qualifies. So any other orders will qualify as confidential information, highly confidential, attorney's eyes only. So they're going to blanket everything the court does. So back to 7 and 8. So then it says, in addition, nothing in this stipulated protective order shall be construed to restrict the ability of any party to seek an order from the court imposing further restrictions on the dissemination of confidential information or highly confidential attorney's eyes only. So if they get this in, they're saying they're allowed to layer on more restrictions to keep the fact that they have no evidence shown. Keep in mind, Tony Rankin is their classmate, a defense attorney also working for them. He admits that clearly. I caught them on calls with him, the guy who was part of their team, talking to Rankin, dictating a letter from me that they wanted to make it like it was from Rankin. He's such an idiot. I caught him doing that, 8 and 9. He screams at me to get out of his office. Door was open. And so he said, wait until I'm done this. Finishes getting the dictation from Kurt Bessinger from Calder, Leslie & Proctor, Warner Brothers firm, and then brings it out to me after he handwritten it, dictated to him. and gives it to me. Just read it and understand this. Trying to have Rankin still control me and represent me for Warner Brothers. So, restrictions on the dissemination of confidential information or highly confidential attorney eyes only information, or seek to rescind, modify, alter, or amend this stipulation protective order without respect to specific information. So what you're saying is this cannot be altered and changed in any way in the future. We get our rights here, highly confidential attorney's eyes only, which we're saying falsely in fraud that this plaintiff wants. So give it to us, right? Using an attorney that is handling him. That nothing could ever change it. No ruling, nothing could ever change it.
Why do you think the clerk doesn't put a line through all of that?
Because it's going to the main. She's going to the main bit that's coming up next.
Okay.
So this, like, what they do is it's called the doorknob speech. I was told this by attorneys. You enter in your first part, which is not as hard hitting, but this is pretty hard hitting. I agree. Pretty scary. Then your last statement of the section will be the one you really want. It's called the doorknob because you're reaching for the doorknob to exit, and this is what you want most, is what you say at the doorknob. That's how it was explained to me. So here's the doorknob. Coming out of that, where it shuts down anything in the future, nothing can be touching it. To the extent that a conflict arises concerning the treatment and level of protection afforded to certain information that is subject to different protective orders, so if we try to get another one in to free up information, it won't hold. This seals everything from the start and never can be opened again. Basically, this is it. You'll never have a chance to argue again. Such information shall be governed and treated in accordance with the narrowest protective order, affording the most stringent protections for such information. Which is saying, basically, if I understand the vernacular, whatever we want protected in the greatest way is what we get. It's like there's no wiggle room. If we say you can't prove, not allowed to enter anything that shows Joel Silver was a producer at Matrix, you can't do anything with anybody or any rule. And it goes to the narrowest protective order, affording the most strongest protections. What they're saying is we want the most solid protection we can get on you getting anything from us, and it can never be changed. This is incredible.
They are the architect.
Yes, well said, well said. Now go to the next one. The terms here are orders of the court and not merely recitals. They're dictating to the court what their orders are going to be. The terms in our documents are orders of the court. They're saying what the orders of the court will be, and not merely recitals. With this document containing the entire stipulation between the parties, the stipulated protective order can only be changed or terminated in writing signed by each of the parties, hereto, and or by an order of the court. See? By the signature of their undersigned attorneys, the parties and their counsel stipulate that they will be bound by the foregoing provisions, and further stipulate that stipulated protective order may be signed, filed, and entered by the court. I haven't even been notified this is going in. I said I absolutely refuse to ever sign it. Reagan said that only goes in if I sign it. And here it is going, parties and their counsel stipulate they will be bound. So this is what it looks like when you have a bought attorney where they brag he's in their pocket, has my back against the wall. This is what it looks like. This is what it looks like. You can get whatever you want and cheat your way. Keep in mind, again, when he was fired, he contacted his butt buddies right away. He contacted Burrow and them right away, a half hour after he's fired. Tell me afterwards in email. Yeah, it's usually, he said, it takes usually a meeting with all present to proceed to summary judgment. But he said, what I'm going to do is, he said, I let the phone call, cheap bastard, let the phone call suffice as that meeting, half hour after he's fired, to allow them to proceed to summary judgment without any objections or evidence filed by us. That's the only way you win a summary judgment. That's the only way you win a summary judgment. That's why when you look up my name, it says he lost his case, because they didn't let me enter any evidence. All we had to do was enter a couple things to counter motion for summary judgment. What he did was he blew our chance at that after he's fired. That's fraud too. Another thing for the case to be resurrected. So what he did was he said, half hour after he's fired, he wanted to brag to me about it, that he allowed them to proceed to summary judgment without any objections, without entering any items that would refute it. That's how you kill a summary judgment. You are allowed to enter items to refute it, and it's done. The courts are supposed to weighing it in favor of the plaintiff in summary judgment. That's why summary judgments are very hard to get. But if you have a planted attorney saying, go ahead and proceed without any objections, no evidence entered, blocking it, then you are going to win anything. You can win that grass is red, because you can enter a case that grass is red by not countering a summary judgment without any evidence, a piece of grass being entered. So that's what he did a half hour after he's fired. Isn't that something? So here we go to another one. There's a lot that hasn't been lined down here because it was just too much. If a party seeks to include or reference any protected material, any filings with the court, so even if I mention it, if I want to mention that Joel Silver was a producer at Matrix, I cannot, because according to this document, if a party seeks to include or reference any protective information in any filings with the court, the party must first comply with the procedures and requirements for filing under seal. No party shall file any documents with protected information without complying with these procedures and requirements for filing under seal. They're taking what's illegal and making it legal by saying that the court is ordering it.
But you can't. You can't.
No.
A court filing cannot be more, will find higher legitimacy than a law.
Right. And and in the event, it says, in the event that this matter proceeds to trial, if any party seeks to introduce information. So when it comes to trial and I get on the stand and I try to say, well, Joel Silver was a producer, I have proof. It goes on, it says here, introduce information designated as confidential or highly confidential, attorney's eyes only. The parties shall meet and confer regarding whether, and if so, in what manner such information can be used and presented at trial. So they can stop me. All my testimony can be stopped. All my exhibits can be stopped because they didn't agree to me having him in, because they're for attorney's eyes only. Upon the final determination of this action, all appeals, yeah, they know they'd be coming, whether by final non-appealable judgment, settlement, or otherwise. So I can't even appeal this or what they do in the future to block evidence. The terms of the stipulated protective order shall be binding in perpetuity for all eternity. On all persons designated in Paris, that's how you cover up. That's how you cover up you have no evidence. And all obligations and duties arising under the stipulated protective order shall survive the determination of this action. So even if it's terminated, it still holds. Imagine Rankin there saying, I want to give them everything they want and be done with my client. And he's letting them get it's like a picnic basket. They can stack it with whatever they want. And he's giving them everything they want. He said he wanted to. Counsel record for each party receiving protective information shall, upon written request by the party that produces protective information, either assemble or return the disclosing parties all documents designated as confidential or highly confidential. So you can't even have a copy of it. Or shall assemble or destroy all documents so designated, including all summaries or other materials, all notes containing or disclosing protective information. Isn't it incredible? You don't even have notes on this of their information. Now, acknowledgement and agreement to be bound by stipulated protective order. This is a death sentence to our case, and it's being sent in. This is to certify that I, the undersigned, have read and am fully familiar with the provisions, stipulated protective order, filed and entered in the case Althouse versus Warner Brothers, herein stipulated protective order. As a condition precedent to the disclosure to me of any confidential information, is written to me, pursuant to the stipulated protective order or my obtaining any information contained in said material, I hereby agree that stipulated protective order is binding upon me, and I further agree to keep all such material information in strictest confidence, and otherwise to observe, comply with, and be bound by the provisions of stipulated protective order. Did I say that at the meeting? Did I say, go ahead, I'll sign this? Did I say, go ahead and send it in? Or did I say, I absolutely refuse to sign this? I will not give my signature. And he promised me they couldn't go in without my signature. Well, he lied there too. I declare under penalty of perjury that the foregoing is true and correct, executed. Now, I'm not there to sign it, right? He told me it had to have my signature. So what does he do? This is binding upon me for eternity. He signs it. Anthony L. Rankin Associates, Anthony L. Rankin by email. He signed it by email authorization. Anthony L. Rankin, attorneys for plaintiff Thomas Althouse. And I wasn't even told it was going in. Do you see what that said? That I'm allowing myself to be bound? And Gary Klausner didn't want to sign it. It was too incriminating. So he has his clerk sign it. December 4th, 2013. Go back to that. Look at that. Look at that. Jose, look at that. Where it says, as a condition precedent to this disclosure to me of any confidential information pursuant to a stipulated protective order or by obtaining any information contained in said material, I hereby agree that the stipulated protective order is binding upon me. And I further agree to keep all such material and information in strictest confidence. I can't talk to anybody. And otherwise to observe, comply with, and be bound by the provisions of stipulated protective order. Now, you talked about the courts being corrupt there, right? And how corrupt they are. Now, keep in mind, remember that bar thing, the Bar Association saying that Tony Rankin was, see there again, look at that. Signed not by me, by him. Remember the Bar Association was saying that how corrupt they are? Well, when Tony Rankin was brought before the bar for all these things, including suspended license, the judge sent a letter to me saying, Tony Rankin won't be charged with anything. This is for your eyes and his eyes only. That will simply remind him not to do it again. Will remind him not to do it again. Only for your eyes and his eyes. That's the level of corruption of Western Court, District 9, in the 20-mile zone in Hollywood, California. Do you want to take a breather there and stop there for today?
Yeah, we will, because we're coming up to 55 minutes, and
perfect. Well, we
we've
got
only
through
got
it.
5 minutes left. But do you
well,
have,
you got through it.
Do
It
you
was
have
a brilliant
do you
idea.
also have the recording of of when you told him I'm not going to sign it?
Yes, we have the recording. It's an MP3. I'll have to look up my files and get it to you. We'll get it to you, because that's where he called me grandiose delusions for thinking Joel Silver
If you
was
can get that
involved in the
to
Matrix.
me, I'll add it to the editing. I'll edit it in.
Okay, I'll have to search for it. We have it. I've got to find it. It's in all our computer documents, so I got to find it.
Good.
But when I find it, I'll let you have it. But isn't it something?
Yeah,
yes, it's clearly defined. Yeah. And that's how corrupt they are in these courts. And that's why Rankin, his job was to protect Joel Silver by posing as my attorney, as a defense attorney. When do defense attorneys act as prosecutors for plaintiffs?
Well,
and when are they classmates?
This should also prove that you weren't afforded adequate counsel. Obviously.
Absolutely not. Absolutely not. Well said. But thanks for doing this today. I hope this hits home. And before we go, let's just take one last, I want people to take a screenshot of this. When they get a chance, take a screenshot of this second page of the attorney-client contract, because this is very important. And then later I've told Jen too, we're going to get those 5 traps that are in this document, this page, and also the first page right here. So we're going to get it's all heading and everything. We'll get the traps that are here spelled out that AI came up with that are in here, which will show you how fraudulent this document is. And that's why he never wanted this shown. He never wanted this document shown. That's why also you'll see in the deposition, I'll send that piece 2, where you'll see in the deposition him arguing, objecting against his own client, objecting that you won't see his contract. And if you try, he'll battle that anyway. He goes on and on. It shows you how scared he is about this being shown, as we're doing right now for the first time in history, really showing it. Thanks for this, Jose.
Yeah, it's my pleasure. Thank you, Tom, for taking the time to show us this. And we'll see you soon. Have a nice weekend.
You too, and thanks for all you do. All right, take care.
Take care. Bye-bye.